Discuss about the different types of the contract. Under Indian Contract Act 1872, the contract can be classified into three segments. First, on the basis of validity. Second, on basis of formation. Third, on basis of performance. On validity, the contract can be further classified as valid contract, void contract, voidable contract, illegal contract, unenforceable contract. On basis of performance, the contract can be further classified as express contract, implied contract, quasi-contract. On basis of performance, the contract can be classified as executed contract, executory contract, unilateral contract, and bilateral contract. So let us try to understand the meaning of these terminology one by one. So types of contract. First, valid contract, absolute contract, contingent contract, express contract, and implied or quasi-contract. Absolute contract term means the contract which is without any condition or without depend on any particular act. Contingent contract is a contract which is depend on some happening of some future event. Express contract means the contract which has been specifically expressed in some form like written contract. Implied or quasi-contract are a contract which are implied by nature. Example, when you go for transportation in the bus facility, you know that the ticket has to be taken, which is an implied. When you go in a restaurant, after the food, you have to pay the bill. This is an implied contract. So, these are some of the mentioned meaning of different contracts. As you can see, valid contract, if all the conditions are fulfilled, it is called as a valid contract. Contingent contract, a contract to do or not to do something. If an event is collateral, does or does not happen, like insurance contract. Express contract, when a contract are either written or in oral, but it is mentioned specifically about the details of contract, is called as express contract. Implied contract, when a contract are neither written nor in oral, but it is implied that both the parties to the contract know the details. Absolute contract, a contract which is not dependent on fulfillment of any condition, is called as absolute contract. Example, when you enter into the contract of sale, you go in any particular shop, you pay the money on the price tag which is mentioned over there, and you purchase that commodity. This is an absolute contract. Invalid contract can be specifically mentioned as void contract or void ab initio, that is a void from the beginning. Voidable contract, when it is an option of one particular party, the contract, whether the contract to be accepted or not to be accepted, irrespective of the other essential factors. Illegal contract, the contract where the legality of the lawful object is not there, it is called as illegal contract. Unenforceable contract, due to the details which are not available or which are not applicable, the contract is not enforceable at the law, is called as unenforceable contract. So if any one of the condition is not fulfilled of the 10 condition of essential element of valid contract, it will be called as invalid contract. An agreement which is not valid from the beginning is called as void ab initio. Example, an agreement with a minor contract are void ab initio. They are from beginning, they are void. Next becomes void an agreement which is valid in the beginning, but due to some supervening impossibility, the contract become void. So this supervening impossibility may occur before or after or between the time of execution. Voidable contract, illegal contract, and unenforceable contract. A contract which is valid unless until avoided by either the party, it is called as voidable contract. So when any one party to the contract does not accept or does not agree to any one particular condition, it is called as voidable contract. Illegal contract, an agreement forbidden by law. So like smuggling, fraud, or doing any illegal act will be considered as an illegal contract. Unenforceable contract, it is a valid, but due to some technical defect the contract become void. In a case defects are removed, the contract is enforceable. That example, lack of signature or not returned registration. So due to any such condition, when the particular contract become void, and in case that particular condition latter get fulfilled, then it is called as unenforceable contract. Other types of contract on basis of performance is executed contract, executory contract, unilateral and bilateral. So executed contract, the contract in which both of the party has executed their part, it will be considered as an executed contract. Executory contract, the content subject matter of the contract is yet to be fulfilled, then it will be called as executory contract. Unilateral, when one particular party only when fulfill its particular obligation and the contract come into end, it is called as unilateral contract. Bilateral contract means when both of the party who are obligated to perform their own both of the responsibilities, it is called as bilateral contract. Now let us discuss the concept of offer or proposal. Under section 2 subsection A of Indian Contract Act 1872, when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. So here if you can see the particular definition as given by Indian Contract Act, the willingness to do or to abstain from doing anything, and there has to be a view to obtaining the assent, so whether the other person should do it or not to do it. So this particular assent or for such act or abstinence is said to make a proposal. So this is the offer or a proposal definition. Further, there are essential rules or legal rules for a valid offer or proposal. First is manner of offer, how you are making an offer. Second, creating enforceable legal relations. So this offer after acceptance and the way you are going to give that subject content in the offer, it should create an enforceable legal relation. Certain terms, the offer may give the certain terms or conditions which require to be accepted or understood in consensus ad idem by the other party. An invitation to offer is not an offer. Example, you make an advertisement, you publish in a newspaper, or you show you display the advertisement at any particular place. That is an invitation to offer, which may not constitute to the valid offer, because if you see many times when there are some advertisement, there are some hash mark or some star mark made and it is written subject to certain terms and condition. So it is an invitation to offer which may or may not constitute the final offer. Specific or general offer. The details when you are going to mention it to offer, they should be very specific, that to whom you are addressing, what are the subject content you are giving, or if you are making a general offer, it should very specifically clear that this offer is open to all and any person who is interested in this contract may come further. Communication is the most important element of a valid offer. The communication mode which you are going to make for an offer should be very clear. Example, A proposes by letter to sell a house to B at certain price. The letter is posted on 10 July. It reaches to 12 July. The communication offer is completed when B receive the letter, that is on 12th July. So the communication of acceptance is complete as against the proposer when it is put into the course of transmission to him, as on out of the power of an acceptor. As against the acceptor, it will come to the knowledge of the proposer, that is on 12th July. So here the communication is most important element when you make an offer. Next is the content which is given into the offer. So the content means the subject matter, what you are offering, when you are offering, how much time that offer is open, and what it is the consideration which the other party has to pay for that. So the content of an offer should be very clear and unambiguous. Terms and condition in the offer. So when you are mentioning the offer, the terms and condition should be very clear to the party to whom you are mentioning, and those should be expected to be in expressed form and not in implied form. Cases of a cross offer. The concept of cross offer, when two parties make an identical offer to each other in ignorance of each other's offer, the offer are cross offer. In such a case, the court will not construe one offer as an offer and the other as the acceptance, and as such there shall be no concluded contract. So the cross offer must be communicated and accepted by each other. So here the cross offer will not be considered as an acceptance but only an offer unless and until those offers are accepted by the both parties. So here we have seen the legal terms associated with the offer. If you want to classify the offer, these are certain classification like general offer, specific offer, cross offer, counter offer, and standing offer. So almost I think I have discussed all these terms with you. The standing offer means the offer which is opened with any particular cutoff date. Like, you know, when you as a company want to issue the shares to the public, you are going to give one particular cutoff date till which you will get an application. So up to that date, it will be a standing offer. So here they have given, we will discuss the cross offer contents. As we discussed earlier, that the cross offer are offer that the parties make to each other in ignorance of each other. Cross offer are identical. In case of cross offer, the court cannot construe one offer as an offer and the other as acceptance of such offer. While a counter offer, on the other hand, is a rejection of original offer. It is a new offer that needs acceptance by the original promiser before a contract is made. Example: if X offer Y agreeing to sell his car and writes a letter to Y offering him to sell the car, and Y also at the same time send a letter to X offering to buy his car, there is said to be a cross offer, as X and Y are ignorant of each other's offer before they make the own offer. However, if X asks Y, will you buy my car for $8,000, and Y says no, but for $5,000, then there is said to be as counter offer. So these illustration example make a very clear distinction between cross offer and counter offer. Last part is the mode of revocation. So when you make an offer, the revocation can be made in the following ways. First, by failure to accept condition precedent. Whatever conditions are mentioned in the offer, if you do not accept the conditions, the offer get revoked or cancelled. By a lapse of specific time, if you do not accept the offer within the specified time limit, then the offer get revoked. By death or insanity of the offerer, the person who makes the offer, if he become insane or the offer is not then offer is not standing and it is get revoked. By rejection of a counter offer, the content which you have given in the offer, if that offer is rejected, then the counter offer is also by giving a counter offer, the mode of the revocation is there for the original offer which is made. By the communication of the notice of revocation by proposer to other party. So when the particular other party to whom the offer is made, if that other party issues a notice of revocation to the proposer, then the particular original offer comes to the end. So in today's discussion, we had seen essential element of the valid contract, then we have seen the types of different contracts, and then mode, meaning and different types of the offer, legal requirements of the making an offer, and mode of revocation of offer. In tomorrow's lecture, we will focus on the concept of consideration and legal rules to make an consideration. Okay, bye. Good.